Hello, everyone, and welcome to Uncivil Law. And for today's case, we have a great opinion written by Justice Scalia in Dissent. This is perhaps his most famous opinion. It's definitely his most famous dissent, and it shows the power of a dissent. This was a 7-1 Supreme Court decision when it was written. So Justice Scalia here is writing for himself, and obviously by a 7-1 count, I don't have to tell you that he didn't have a lot of people in his favor. But since the years have passed, this has become more and more accepted in the legal community. This seems to be more along the lines that more people are thinking these days. And you can see this in some of the more recent jurisprudence from the Supreme Court. So it goes to show the powerfulness of a well-written dissent, and also is an example of some of Justice Scalia's best work. Again, his well-regarded opinion among people, perhaps his best opinion, definitely best dissent, and for if no other reason, then it's gone to show the power to persuade. It might just be his best dissent just simply for the basis that it is going to basically change the law. So he kind of won in the end. So for no other reason, it's the best dissent he ever wrote. So we're going to read his dissent. This case deals with an independent counsel statute. So there was a statute that Congress passed that allowed for an independent person to become a prosecutor. So it allowed to prosecute political officials, prosecute the president, and so forth and so on. And so Justice Scalia is writing here about the constitutionality of the independent counsel statute. Can Congress create a prosecutor that is not subject to the president? All right, so that's the issue. Let's read what he has to write. The principle of separation of powers is expressed in our Constitution in the first section of each of the first three articles. Article 1, Section 1 provides, all legislative power herein granted shall be vested in a Congress. Article 3 provides, the judicial power shall be vested in one Supreme Court. And Article 2, Section 1 says, the executive power shall be vested in a President of the United States of America. So we have the first three articles to the Constitution. We have Congress, President, and the Supreme Court. And each one in its first section says, all the respective power belongs to the respective branch. So all the legislative power belongs to the legislature, all the executive belongs to the executive, all the judicial belongs to the judicial. So that is the first principle the Constitution recognizes. The founders conspicuously and very consciously decided to sap the executive strength in the same way they weakened the legislature by dividing the executive power. Proposals to have multiple executive or councils of advisors with a separate authority were rejected. So here the Supreme Court is pointing out that in the legislative section, they divided the legislative power. They divided it between a Senate and a House of Representatives. And even in the judicial power, as we learned from Marbury versus Madison, they even divided the power. They divide the power between the Supreme Court and inferior courts. That's what Marbury versus Madison stood for. So the Supreme Court has original jurisdiction in some cases, and in some cases, only appellate jurisdiction. And it's up to a lower court or lower body of some kind to hear the case in the first example. So even in the judicial context, they divided power. So they divided power in the judicial context between Supreme Court and inferior courts. In the legislative, they divided power between the House and the Senate. But in the executive, they didn't do any kind of division. There's nothing like that in Article 2. It seems pretty clear on its face. All the executive power belongs to the president, and any power that is derived from that belongs to the president. So in the strictest sense, the president can do anything because he has all the executive power, and everyone else just serves at the pleasure of the president, or as an agent of the president, maybe, to put it more properly. They all serve as some fraction of whatever power he had to start with. So anytime the executive is doing anything, the president could do it directly. They're just serving as an agent for that purpose. So that's kind of the idea that Scalia is talking about. That is what this lawsuit is about: power. The allocation of power among Congress, the president, and the courts in such fashion as to preserve the equilibrium the Constitution sought to establish, so that a gradual concentration of several powers in the same department can be effectively resisted. So they're trying to create separation of powers to prevent any one branch from becoming too powerful. And so we have to maintain the separation to make sure that we're doing that. Frequently, an issue of this sort will come before the court, clad, so to speak, in sheep's clothing. The potential of an asserted principle to effect important change on the equilibrium power is not always immediately obvious, which it's not. So sometimes the issue is a little bit hidden because, you don't necessarily always think of it right away. And so you must be careful when you're analyzing it to see if it's an issue. But here Scalia says the wolf comes as a wolf. So sometimes the issue might be hidden and a little bit more concealed, but here it's pretty obvious. We're creating an independent counsel, which seems to be executive power. So we're not trying to hide the ball, nor is the ball hidden. So sometimes it's possible for Congress to pass a statute and not even know what they're doing, right? So sometimes they might infringe on one of the branches without even realizing it. That's possible. In some cases, likely, depending on your point of view, Congress may not be able to Congress all the times. So sometimes they don't even see the issue. But that isn't the issue here. They definitely saw the issue. We're not trying to hide it. We didn't fail to see it. No, we're definitely just saying this is the thing we're trying to do. Okay, so is it a thing we can do? Let's find on. The present case began when the legislative and executive branches became embroiled in a dispute concerning the scope of congressional investigative power, which, is kind of like basically how all these kind of disputes start. Congress wants to investigate, the president wants to say no. This is not the first time we've done this, nor is it the last. It's been an issue basically every presidency ever since basically the beginning of time. Yeah. So when this issue comes up, which, it comes up quite a lot, the branches get angry at each other because, of course, they do. So what happened in this particular case, not that it particularly matters because it's just the longest running in a series of things. So what happened here, not that it really matters anyway, but what happened here is that there were oversight hearings into the administration of the Superfund of the EPA. And two subcommittees of the House of Representatives requested and subpoenaed numerous internal EPA documents. So the Superfund is the thing that helps clean up toxic waste. And so there's some administration, and Congress says, please give us internal documents. Okay. The president responded by personally directing the EPA not to turn it over. In the decision to exert this executive privilege, which is one of the grounds that the president often does, this goes to the core of the executive function. So I have a privilege, which I'm just going to declare I do because I can. So the president declares this privilege that he says exists. The president was counseled by the appellee Olson. Yeah, who's a lawyer who was then assistant attorney general, and he's a fantastic lawyer, fantastic advocate. Olson's great, he's one of the best, and so he was then an assistant attorney general of the Department of Justice for the Office of Legal Counsel. So he's serving in the Office of Legal Counsel, which is the group you go to with, is this legal? So he's writing an opinion. So he says, don't do it, or you're allowed not to do it at least. So Olson said, yeah, that's fine. You cannot do it if you want. The House's response was to pass a resolution citing the EPA administrator who had possession for contempt. So the Office of Legal Counsel, which is the group within the agency that says, here's what you can do legally and not, the president says, can I refuse to do this? Office of Legal Counsel says, yeah, you can refuse to do that. So they refuse to do it. And now Congress wants to hold them in contempt. And then they note here that contempt is a criminal offense. It can be, yes. So then the United States Attorney, which remind you which is an executive branch official, initially took no steps to prosecute this because that's how this works. So yeah. So this is just the latest in a long-running series of things. Congress wants some internal documents. The president says no. They go to the core of the executive function. I don't want to. And so then the Office of Legal Counsel says, yeah, you can refuse to give them if you don't want to because this is kind of par for the course. So then the EPA director, under the order of the president, the EPA director says, I'm not going to give you the documents. Okay, great. So then Congress holds them in contempt, which is also something that happens quite frequently. But of course, contempt is a criminal sanction. Well, who prosecutes that? Well, that would be the executive. The very executive that ordered you not to do it in the first place. So the executive, of course, says, don't prosecute it because I'm the one who directed it in the first place. So of course, I'm not going to prosecute myself. That would be dumb. And so that brings us to the situation. The executive says don't do it, and then also don't prosecute me for not doing it, and Congress just ignore that contempt. So yeah, that's kind of just par for the course. This is just repeating what we've done many, many times. Yeah, great. The district court declined, in Scalia's view correctly, to get involved in this controversy, which is pretty typical as well. This is a very common response to these fights. A lot of the time, the judicial branch says, just leave us alone. So if you have the executive and legislative fighting each other for power, one very common response is it's a political question. And so a very common response is, it's a political question. We don't want to get involved in your tiff. You guys figure it out amongst yourselves. We don't care. We don't care and we don't want to get involved. So this is very, very common. Leave us out of it. So the district court said, leave us alone, which is a very common response. Yeah. And then urged the other two branches to try to figure it out. But of course, that wasn't the end of it because there was an independent counsel statute. So there was a statute that said you can have an independent counsel who can be directed to do stuff. So now we have to figure out, is that a thing that they can do? All right, great. So let's figure that out. As a general matter, this independent counsel statute here requires the Attorney General to apply for the appointment of an independent counsel within 90 days after receiving a request to do so, unless he determines there's no reasonable ground to believe further investigation or prosecution is warranted. So the U.S. Attorney has to appoint an independent lawyer, independent from himself, independent from the prosecution, independent from the president, to prosecute these crimes, because Congress said, hey, there's a conflict of interest here. You can decide not to prosecute yourselves, but we want the authority to hold you in contempt, and we want someone independent to figure out whether or not that's something they can do. So can we create an independent lawyer? All right, let's figure that out. Thus, by application of this statute in the present case, Congress has effectively compelled a criminal investigation of a high-level appointee of the president in connection with his actions arising out of this bitter power dispute between the president and the legislative branch. Mr. Olson may or may not be guilty of a crime. We do not know. I'm not sure how that's 100% possible, simply since he's a lawyer and giving a legal opinion, but whatever. But maybe he's guilty of a crime, but more to the point, maybe his boss is guilty of a crime because he's the one who refused. But we do know the investigation of him has commenced, not necessarily because the president or his authorized subordinates believe it's in the interest of the United States. In any sense, it warrants the diversion of resources from other efforts and is worthy of the costs and possible damages to other interests. So it's not like the executive said, well, let's look into Mr. Olson, balancing all that out. That wasn't happen. And it's not even leaving aside these normally considered factors because the president or his authorized subordinates believed it's necessary. Is likely unworth a violation prosecuting. So this wasn't like some internal DOJ matter that somehow came about, and it wasn't even like the president himself directed it, which is a little unusual because normally the Department of Justice is kind of independent from the president, although strictly speaking, not really, because the president can give an order to the Attorney General, and the Attorney General can give an order to the Department of Justice. But normally they're kind of independent, so it's not like this came about as some normal mechanism, and it's not like it was extraordinary because the president himself directed it, but rather because the Attorney General cannot affirm that there are no reasonable grounds that further investigation is not warranted. So it's not like they came to some considered decision, rather it's because they're being forced to. Decisions regarding the scope of further investigation and its duration, and finally, whether or not to prosecute, are likewise beyond the controller or subordinates. So, this isn't a normal situation where Department of Justice is like looking into something and trying to prosecute someone within the executive, incidentally, and trying to figure out whether or not that's okay or whatever. And it's not even some extraordinary situation, which always pops the eyebrow a little bit, because the president is kind of directing something that maybe he shouldn't be directing, even if technically he has the power, maybe he shouldn't be doing that. So it's not even like one of those situations. Rather, the Attorney General is being forced to, and this person can prosecute now without the Attorney General's approval, without the president's approval, without anybody's approval. He can just prosecute people. That seems a little bit weird. All right, so let's read on and figure out whether or not we can do that. Scalia continues by saying, if to describe this case is not to decide it, which I love this language very much. He's saying, okay, merely by telling you about the case, the outcome should be obvious, right? I shouldn't have to write anymore. Because I've just described it to you. Merely by describing it should be enough. But if somehow it's not enough, let's press on. The concept of government as separate and coordinate powers no longer has meaning. The court devotes most of it, he's referring here to the majority opinion, the court in its majority devotes most of its attention to relatively technical details, such as the appointment clause and removal power, addressing briefly and only at the end the issue of separation of powers. So the Scalia thinks that the majority is kind of working on the minutia, working on this little kind of inconsequential data and ignoring the big issue of, hey, does this violate separation of powers? So what is the legality of this appointment? What is the legality of the removal of power? Instead of going to the more fundamental, basic question of, does this violate fundamental rights or fundamental power? And then Scalia writes here, as his own prologue suggests, I think it has backwards. Yeah, maybe we should focus on the more fundamental, more dire aspect of, does this go to the root of separation of powers rather than worrying on the technical minutia? Maybe that's not the most important thing. Maybe we should be focusing on the big thing first. Kind of agree with Scalia on that one, yeah. First, however, I think it well to call to mind an important and unusual premise that underlies our deliberation. A premise not expressly contradicted by the court's opinion, but in my view, not faithfully observed. It is rare in a case dealing, as this one does, with the constitutionality of a statute passed by Congress, not to find anywhere in the majority opinion the usual, almost formulaic caution that we owe great deference to Congress's view that what is done is constitutional, and that we will decline to apply a statute only if the presumption of constitutionality can overcome. That caution is not present in this case because it does not apply. So Scalia is saying there's a normal caution that they just write as of rote, which is normally we defer to Congress, and we owe them a great deal because normally we think it's constitutional. And Scalia is chiding the majority. He's saying the reason they're not mentioning it is because if they did, they'd have to contend with the fact that this is one of those unconstitutional times. So he's saying, well, it's not there because it doesn't apply, so we're not going to mention it. We're going to ignore that fact. Nice little backhand there at the majority opinion. To repeat, the Constitution provides, always a good place to start. What does the Constitution actually say? That's a really good place to start. So it says, quote, the executive power shall be vested in a president of the United States, unquote, end of sentence, end of paragraph, basically. Seems to suggest all of it. Seems kind of clear, yeah. As I described in the outset of this opinion, that does not mean some of the power, but rather all of it. It seems to me, therefore, the decision of the Court of Appeals in validating the present statute must be upheld on fundamental separation of powers principles if the following two questions are answered in the affirmative. Is the conduct of a criminal prosecution and the investigation the exercise of executive power? Does the statute depend on the President of the United States of exclusive control over the exercise of that power? So if those answers are in the affirmative, that would seem to suggest that it belongs to the President. Surprising to say, the court appears to concede the affirmative answer to both these, but then seeks to avoid the inevitable conclusion that would follow, since the statute vests some purely executive power and a person is not present is void. So Scalia says the majority here concedes the premise and then tries to avoid the conclusion of those premises. Well, how do they do that? The majority concedes there is no real dispute the functions performed by the independent counsel are executive, yes, though it qualifies that concession by adding in the sense that there are law enforcement functions that typically have been undertaken by officials within the executive branch. This qualifier adds nothing but atmosphere. It's not much of a qualifier. Yeah, in what other sense can one identify the executive power that's supposedly vested in the president, unless it includes everything the executive branch is given to do, except by reference to what is always done, if conducted by government at all, to be conducted never by the legislature, never by the courts, and always the executive. So Scalia is basically saying, how could this not be executive power? It has always been executive power in every form of government ever known to man. This is executive just definitionally. So what are you talking about? So there's no possible doubt that this functions as executive. It is executive in every possible context and every constitution in the history of time. This is definitionally executive, yeah. As for this second issue, having decided that it's an executive function because of course it is, whether the statute before us deprives the president of exclusive control over that quintessentially executive act. The court does not and could not possibly assert it does not. That is indeed the entire object of the statute. Yeah, right. So that would be, so does this statute deprive the president of his executive role? Well, it's the independent counsel statute. That is its exact direction and goal in mind. That is exactly and 100% at its core what it's trying to do. So maybe some other statutes we could have a debate about, but not so much here. The entire point of this statute is to take this person out of the control of the president. So when you ask a question like, is this out of the control of the president? It's like, yeah, that is its core purpose, its sole directive. It is what it's seeking to accomplish at its very heart and soul. Not a lot of thought needs to go into this. As we recognized in a very famous case called Humphrey's Executor, which deals with independent agencies, limiting removal power in general to good cause is an impediment to not a grant of presidential control. Right. So if you say you can only fire for good cause, that impedes the president because he could fire for any cause otherwise. All right. So that was, yeah. We have said this limitation was necessary with respect to members of the Federal Trade Commission, which we found to be an agency of legislative and judicial departments and wholly disconnected from the executive department because it's quite evident that the one who holds his office only during the pleasure of another cannot be depended upon to maintain the attitude of independence against the latter's will. What we rolled in Humphrey's Executor was found to be a means of eliminating presidential control. The court asserts today to be the most important means of asserting presidential control. Humphrey's Executor deals with independent agencies, and many independent agencies have heads that can only be fired for cause, good cause. They can't be fired just at will. And so that is also an impediment to the president. And so what the Supreme Court ruled in Humphrey's Executor, which has since become questioned under time, mostly because of this dissent. So the people question Humphrey's Executor for exactly this reason. But they said, look, in the case of an independent agency, they have functions that aren't purely executive in mind. So they have some roles that are legislative, kind of. They have some roles that are judicial, kind of. So if you think about the FTC, right, they have to create all these regulations on Federal Trade Commission dealing with goods and services and legality and whether products are safe and so forth and so on. So they have to create all these regulations, which are kind of quasi-legislative, and then they have to deal with adjudicating those. So maybe those are quasi-judicial. And also somewhat of note in these cases, and this became a point of contention in a later case, there is not a sole head in these separations. So the Supreme Court would much later go on to rule that you can't have a single agency head that is separated for good cause. But what you can do, at least Humphrey's Executor goes this far, what you can do is you can have a panel. So you can have a group of people like you do at the FTC or the FCC or dealing with the elections, FEC. So you can, the Federal Trade Commission, Federal Communications Commission, Federal Election Commission, you don't have sole heads. You have the head of the office is a group of people. And so you have these panels that exist, and it's kind of quasi-legislative, quasi-judicial. And the Supreme Court would later rule, well, you can't have a single agency head. That was the case in the Consumer Protection Bureau, dealing with that, and said, no, you can't do that. So this has become questioned because of this decision, because there's also some executive function here. But maybe it's different because it's not solely executive or purely executive. So maybe we can distinguish on that grounds. Okay, so to the degree to which you think that makes sense or not, in line of the Constitution, I think is still an open question. But this is still good law today. But it's become more questioned because of this. So, at the moment, you have these agencies which are independent because they're not purely executive. They have some quasi-legislative, quasi-judicial functions, and they're multi-panel heads. And so we can distinguish on the grounds. Whether or not we should distinguish on the grounds is still a whole other issue, but that was Humphrey's Executor. Okay. But of course, this statute is a little bit unlike that because we're not creating a multi-person panel. We're creating a guy as a core executive function prosecuting. So even if you can distinguish the FTC, FCC, FEC, even if you can distinguish it, it's like, well, you can't distinguish it on those same grounds here because you don't have someone who's of multi-functions. It's a purely executive function prosecuting, pretty much purely executive, and it's one guy. So whatever logic there might be to Humphrey's Executor can't possibly apply here, yeah. As I discussed above, the condition that renders such a request mandatory, the inability to find no reasonable grounds, is so insubstantial that the Attorney General's discretion is severely confined. So it's not discretionary, it's mandatory. And once the referral is made, it's for the special division to determine the scope and duration of the investigation. So once the Attorney General is forced to make this, the special division itself gets to determine its scope and duration on its own, with no review. That seems like a problem. In any event, the limited power over the referral is irrelevant to the question as to whether, once appointed, the independent counsel exercises executive power. Finally, the court points out that the Act directs the independent counsel to abide by general department policy except where not possible. What does that mean? And since it's the independent counsel, they're the one who has to figure it out, which means that they can just make up their own stuff. So they get unlimited power, unlimited scope, unlimited duration, and they only have to obey the rules unless they don't want to. The exception above shows this to be an empty promise. Even without that, however, one would be hard put to come up with many investigations or prosecutorial policies that are absolute. Yeah, even though this is kind of one of them. As I've also said, however, it's ultimately irrelevant how much the statute reduces presidential control. The case over whether the court acknowledges it, as it must, is it's undisputable the Act reduces the amount of control or supervision that the Attorney General and, through him, the President exercises over investigation and prosecution, over certain classes of alleged criminal activity. This takes away their ability to control, and they are politically accountable, unlike this other random guy who's not politically accountable because he doesn't report to anyone who's politically accountable. So this statute, this independent counsel statute, affects a revolution in our constitutional law for the court. So once it is determined that purely executive functions are at issue here, which they are, unlike Humphrey's Executor, this is purely executive. And those functions have been given to a person whose actions are not fully within the supervision and control of the president, it nonetheless proceeds to further sit in judgment of whether the president's need to control is so central to the functioning of the branch as to require complete control. So we're now answering like random questions we're inventing. Whether the conferral of the power upon someone else sufficiently deprives the president of control over independent counsel to impermissibly interfere with the constitutional obligation to ensure faithful execution of the law. And whether the act gives the executive branch sufficient control over independent counsel to ensure the president is able to perform his duties. It is not for us to determine, it has never been presumed to determine how much of purely executive function must be within full control of the president. So one of the things Scalia has pointed out here is that you have determined what should be the core issues. This is purely executive in nature, unlike Humphrey's executive. And the president doesn't have control. So that should settle the matter. But what you, the majority, have written, well, it's not that big a deal because it doesn't infringe his power very much. It's just a little bit of infringement. So it's totally cool. It's not sufficiently impeding. It doesn't go to his core functions. And Scalia's over here like, what are you talking about? The Constitution says all the executive power belongs to the president. This is purely executive. And now you're saying, well, even though it's not all, it's like a lot of it, so that means it's totally cool. And Scalia's like, where are you coming up with this? Where are you deriving the idea that, like, if it's not that much, it's not that big a deal? And incidentally, how are you deciding how much is not too much? How are you, like, what are you pinning that on? You know, what is the limiting principle? So even assuming this was true, like, what are the limits of this? Can Congress go further than this? How much further? And how do you know the answer to that question? And Scalia says the majority is just kind of hand-waving and saying it's not that big a deal. Scalia says it's kind of a big deal. The utter incompatibility of the court's approach with our own constitutional traditions can be made more clear, perhaps, by applying it to the powers of other two branches. So Scalia over here is going to say, because you couldn't get the point, let's pretend that this was being applied to a different branch of government and how that might look. So let's look at what the equivalent would be somewhere else, and then by trying to apply this into a different branch of government, we can realize how utterly insane it is. So let's give that a shot. Let's try to apply this logic to a different branch of government and see what happens. So what if Congress passed a statute depriving itself of less than the full and entire control over some insignificant area of legislation, which incidentally is not that impossible. That is like just a further extension of the administrative state. So Congress now when the executive is doing stuff, the degree to which that's legislative is tricky. But what if the legislature went even further? What if they went even further than they have and they actually devolved themselves of some of their core legislative function? What if they went that far? All right, which doesn't seem that impossible given what they've done. What if they decide we can't be bothered to legislate, so we're going to give some of our legislative function somewhere else? But it's insignificant. It's insignificant, so even though it's core legislative function, it's not that big a deal. All right, so what if we tried that? So would we inquire whether that matter was so central to the functioning of the legislative branch as to really require complete control, or whether the statute gives Congress sufficient control over this surrogate legislature to ensure Congress is able to perform its duties? Of course, we'd have none of that. Yeah, that doesn't make sense. If Congress was truly devolving itself of its own legislative authority, no, you can't do that. No. So, no, just no, you can't do that. Once we've determined it's purely legislative, the issue would require it to be excised wholly entirely by Congress. Only Congress can legislate. If it's purely legislative, Congress can't devolve itself of its own legislative function, even if it wants to, which incidentally, it might want to because Congress can't be bothered sometimes. No, only Congress can pass legislation. Or to bring this point even closer to home, how would this affect us? How would this affect us in our home, the judiciary? So let's give that a shot. Let's consider a statute that would give to non-Article 3 judges, so to the judicial. What if there was a statute that gave to non-judicial branch people just a tiny bit of pure judicial power? How about that? What if we tried to create things that aren't courts to do judiciary stuff? But it's insignificant. It doesn't really matter. It's just little, it's just a little judicial power, just a little taste. So what if we gave this little taste of judicial power to non-judiciary? What about that? In this insignificant matter, but with substantial control, although not total. Perhaps this could be something like clear error review. So maybe when we're trying to figure out if a district court made a clear error, maybe 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 we could make that an administrative issue. That's not that big a deal. Maybe it should be an administrative agency that figures out if the district court made clearer. How about that? And that would be fairly equivalent to the Attorney General's for-cause power here. And not that big a deal in the grand scheme, which I guess, maybe. Is there any doubt that we would pause to inquire as to whether that this was so central to the judicial branch as to really require our complete control, or whether we retain sufficient control over the matter? Or would we say our constitutionally assigned duties include complete control over the judiciary? So Scalia over here is like, okay, what if we applied this logic to the other branches of government? Because presumably we could. I mean, the Constitution says all the power belongs to the executive, and the majority says, no, it doesn't. Some of it belongs somewhere else. And it's like, okay, let's give that a shot. What if we said all the legislative power doesn't belong to Congress? What if some of it belongs somewhere else? Or what if all the judicial power didn't belong to the judiciary? What if some of that belongs somewhere else? Would we be cool with that? We'd say, yeah, that makes sense. It's not our core judicial power. It's not our core power. It's ancillary and we have sufficient control. It doesn't go to the heart of what we're trying to do, blah, blah, blah. Does that sound like the kind of thing we'd write? Doesn't sound like the kind of thing we'd write to me. But for some reason, even though we never even dream of it in judiciary land, we think it's cool in executive land because, I don't know. I can't figure it out. Scalia, I'm with you, man. I'm with you. I can't figure this out either. It doesn't make any sense. Is it unthinkable the president should have exclusive power even where the alleged crimes by him or his close associates are at issue? So that is a reasonable question. That is a reasonable question, kind of the equivalent of, judge should be the judge in his own case, right? So if you had someone trying to judge their own case, that might be a problem. And also, incidentally, like a challenge to the power. So can the president pardon himself? That's always a question. And one of the issues might be, well, that's being the judge in your own case. So, should the president have exclusive power even where it's him or his close associates? So is that unthinkable? It is no more unthinkable, says Scalia, than Congress should have the exclusive power of legislation even where it's trying to exempt itself. Yeah. So if you think it's unthinkable for the president to decide whether or not to prosecute himself, if you think that's unthinkable, well, presumably it would be equally unthinkable for Congress to legislate exemptions to itself, which it can do. And it would be also unthinkable for the judiciary deciding cases such as salaries of justices. So if Congress has passed a law that impacted the salaries of justices, the justices themselves would have to decide whether or not that's constitutional. So even though they're self-interested in some sense, because it's going directly to how much money they get, well, the judiciary has to decide whether that's legal, even though it directly impacts them. So if it's unthinkable for the executive to exercise its power to decide whether to prosecute itself, it's unthinkable for the legislator to legislate itself, and unthinkable for the judiciary to judge itself. But that's kind of where we are, because that's where the Constitution requires. And there are checks on that, namely the other branches of government and federalism and a whole bunch of things. So even though there is in some sense unchecked power, in another sense there's checked power, because there is redress, not exactly in that situation, but in other contexts for the other branches of government. So that's how this system is set up. So even though the executive gets to decide whether to prosecute itself, there are checks somewhere else, like impeachment, for example. So then he goes on to write, a system of separate and coordinate powers necessarily involves acceptance of exclusive power that theoretically can be abused. Yeah. As we reiterated today, it is a truism that constitutional protections have costs. That's always true. First Amendment has costs. The First Amendment isn't free. Second Amendment isn't free. The Fourth Amendment isn't free. It has costs. It has costs. There would be things that we would be able to do if the First and Second and Fourth Amendment didn't exist. And some of those things might be good in some sense. At least they're at least arguable. It would be at least arguably good. It would be at least arguably good if the executive if the Fourth Amendment didn't exist. Then the police could go into anyone's home they want, and they could discover any crimes they want, and would make prosecuting crime more efficient. So we'd find more lawbreakers. I mean, there's that, right? So if the Fourth Amendment didn't exist and the executive could just search anybody anytime, it would probably lead to more criminals being arrested and prosecuted. So that might be good. So the Fourth Amendment isn't free because now we can't do that. It comes at a cost, but we've decided the cost is worth it. So yeah, the First Amendment, Second Amendment, Fourth Amendment, or for that matter, the entirety of the Constitution isn't free. There are things that are imbalanced. There are things that are costing. They're not free. There's no free ride. When you do something, you don't do something else. So All these constitutional provisions have antecedent costs, but those costs have been deemed worth it. They've been deemed worth it, and they are worth it. So it's like, yeah, so we've already kind of done that. So while these separation of powers issues may prevent us from righting every wrong, Fourth Amendment, for example, is sometimes inconvenient, yes, it does so in order to assume that we don't lose liberty. So even though it prevents us from righting every wrong, liberty in the whole is more important. The checks against any branch's abuse of power is twofold. So what is the check? First, the retaliation by one of the branches of its power. Yeah, such as impeachment or whatever. So there are other checks from other branches that they can do. Congress, for example, can impeach. The executive can decline to prosecute. And the courts can dismiss malicious prosecution. So even if the executive wants to prosecute people and has this power to decide, one of the things the court can do is go, how about no? How about no? You can't prosecute this person because we say so, because we're the Justice Department, we're the judges, and this is malicious. So even though you're trying to abuse this power by prosecuting your enemies and so forth and so on, the judiciary can say, how about no? None of that for you. So yeah, there are checks. Secondly, and ultimately, there's the political check, which is the ultimate check on all of this. The people can replace those in the political branches who are guilty of abuse if they don't like what's going on. So yeah, there's that. The majority, however, has replaced this clear constitutional prescription, which is when you say you must do something, it's prescribed. The executive power belongs to the president with a balancing test. Ooh, balancing test. That sounds fun. Let's replace it with this balancing thing that we're going to invent for some reason. What are the standards to determine how the balance is struck? Always a really good question in law. What are the limiting principles? How are you balancing this? Against what? So how much is too much? Good question. Many other countries of the world get along with an executive that's much weaker than ours. That's true. Like there's no inherent rule on how much power the executive or legislative or judicial should have, right? So some other countries, the executive is comparatively stronger and sometimes weaker. Sometimes the legislative is stronger, sometimes weaker. Sometimes the judiciary is stronger, sometimes weaker. There's like no inherent rule that says, well, the executive has to be this strong. Sometimes they're pretty weak. So, we could have a different system where the president was weaker than it is. In some cases, it's entirely dependent on the legislature. Yeah, sometimes the executive is a little bit more than the legislative puppet, which is true in a lot of prime minister systems, depending on your point of view. Once we depart from the text of the Constitution, just where do we stop? The most amazing feature of the court's opinion is it does not even try to give an answer. That's really concerning. It simply announces, with no analysis, the ability to control the decision, whether to investigate and prosecute, and indeed the president himself, is not central, as to be constitutionally required. Apparently that's true because we say it's true. Yeah, they don't even attempt to answer it. It's just like, it's true because it's true. Scalia's like, as much value as it's true because we say it true might have in some situations. In this particular situation, not really super persuasive. You're taking authority from the president. You want to try to come up with any limiting principle at all on how much is too much? No, it's just true because we say it is. And leaves a little bit to be desired in these circumstances. Evidently, the governing standard, so apparently the standard, such as it is to be what might be called the unfettered wisdom of the majority of this court. Apparently, the standard is whatever 5 of us agree is. That's super promising. That is not only a government, that is not the government of law. It's not a government of laws at all. Yeah, it's not even laws because it is whatever we say it is whenever 5 of us agree. No, not really super feeling that one over here. Yeah, I kind of understand where Scalia is coming from. In sum, this statute does deprive the president of substantial control over the prosecutive functions performed by the independent counsel, and it substantially affects the balance of powers. That the court could possibly conclude otherwise demonstrates both the wisdom of our constitutional system, in which the degree of reduced control and political impairment were irrelevant, since all purely executive power had to be in the president, and the folly of the new system of standardless judicial allocation powers we adopt today. Thus, that brings us to the end of Justice Scalia's dissent in the case of Morrison versus Olson, in which Justice Scalia, in a 7-1 opinion, so he's on the one end, Justice Kennedy didn't take part, that's why it's 7-1. So Justice Scalia here gives a constitutional primer, and he says that all the executive function belongs to the president. And he says that even if you can distinguish from Humphrey's executor in those cases where you have independent agencies, which are performing quasi-judicial, quasi-legislative functions, even if you can distinguish, you can't make that separation here. This is a purely executive function. The decision of whether or not to prosecute is about as core executive as it gets, and this guy is a one-person entity unto himself who can decide what to prosecute, for how long, what duration, and it's completely unbounded. So that's all sorts of super. And so the Scalia points out, yeah, that goes kind of to the core of the function. And Scalia says, well, the majority thinks it's not that big a deal. And then Scalia points out, how are you even determining what makes it a big deal? And Scalia concludes the majority says, well, just basically because we say, and that's not really super persuasive. So yeah, so since this dissent was written by Justice Scalia in 1988, this has become much more the dominant view, and you definitely see it reflected in today's Supreme Court decision. So it goes to show the power of dissent, and goes to show the power of Scalia's dissent and his philosophy. Probably the greatest dissent he ever wrote, maybe the greatest opinion he ever wrote. That's Morrison versus Olson. Brings us to the end of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.